Let's bring in the guest of the day for the network. Landmark decision. Federal judges ruled Google violated antitrust law by illegally maintaining a monopoly over Internet search. Jonathan Kanter, Assistant Attorney General for the Justice Department's Antitrust Division, joins us first on CNBC. And first, Mr. Kanter, congratulations on what I think is a very, very big win.
Thank you, Jim. It's great to be with you again.
Well, let me ask you, when a judge rules that someone is a monopolist, which means exclusive agreements have reduced incentive and innovation, what could possibly be the remedy? Because how do you break the exclusive agreement? How do you get incentives and innovation started again?
Sure. This is a familiar problem. So these kinds of exclusive agreements were at the center of the US v. Microsoft case, and the court observed there, as I would observe here, that there are remedies for all things but death. And at the end of the day, what's most important is that we meet the market where it is. We reflect market realities as they exist today. And we look ahead at what the next inflection points coming down the pipe are in terms of competition and protect them from anti-competitive conduct.
Well, Mr. Kanter, while Google won, it would seem that there's an unintended consequence here. Apple, which is who's involved in getting the payments, they lose the payments. It's most likely, as the judge says over and over again, that Google's predominance won't change because it has a superior product. So isn't the loser Apple, not Google?
Well, the losers were competition during the conduct, the anti-competitive scheme that Google perpetrated. But the loser, the decision is Google, right? Google is a monopolist. It illegally obtained its monopoly power. And now we need a remedy to make sure that we sufficiently address the anti-competitive conduct and provide opportunities for new innovators to reach market. There'll be a process, an orderly process that the court will put in place. I want to respect that process that's going to happen. The court has ordered a conference in September, and we'll talk about remedies. But like I said before, in a market that involves technology and dynamic products, it's important that remedies actually meet the moment in all of our cases, and that they meet the market where it is right now.
Well, Assistant Attorney General Kanter, you just said it. You said that you have to take care of watching what the changes are, the dynamic. I have here in my hand a July 25th Search GPT prototype that Microsoft, using Copilot and Search GPT, wants to put together and will do a search engine. Now, there's 200 pages devoted to the fact that there's no competitor to search, so therefore you have to do this. Could you not be overridden by the events of July 25th, 2024 Search GPT prototype?
These are factual questions. The court addressed a number of these questions in its lengthy opinion that was extremely rigorous, detail-oriented, relied on expert testimony as well as documents and data. The fact of the matter is competition often matters most when there are new inflection points that emerge in the market. And monopolies have the greatest incentive during those inflection points to stifle competition before it has the opportunity to take hold. So right now is perhaps the most critical inflection point we've seen in the search market in 15 years, and making sure that it has the opportunity, that competitors have the opportunity to compete on the merits, benefit of their own innovations, and win or lose based on the merits of their products is the most important thing right now.
Mr. Kanter, just a couple of questions on process so investors can get an understanding. What happens, you mentioned you're going to be in September, you're going to be, talking about remedies with the judge. Google, I would assume, has an opportunity to be a part of that as well. Can you just give our viewers a sense as to what happens from here, both that, the remedies, and then what's going to be an obvious appeal and how that all plays out, and whether remedies take place in the interim or wait for the appeal to actually take place as well?
Yeah, so that'll have to play out in the court process, and I want to respect that. So I can't really comment other than to say that the court will order a path forward. In the past, there are cases where courts have effectively conducted a remedies trial. There are other cases where different outcomes and different processes were put in place. That will be up to the court. We look forward to being there, and we look forward to making the arguments we need to make in order to protect competition.
Will you you won't share in any way what you would like to see in terms of a remedy, or are you willing to do that?
I think it's premature for us to talk about that right now. We look forward to engaging with the court throughout that process. But For today, we're really thrilled with the outcome. I'm really proud of our team, which fought day in and day out against a formidable adversary to bring the facts forward, and we have a decisive victory in hand.
Mr. Attorney General, what is wrong with Google paying Apple?
So we covered this in our case. When it's one thing to companies to engage in legitimate commercial interactions. It's another thing to pay somebody in exchange for exclusivity. It's another thing to pay somebody with a requirement that they don't work with a rival. Those are the kinds of issues that when you have massive amounts of monopoly power can violate the law. The law is pretty clear here, and we brought those facts. We explained why it was a problem. We explained why it harmed competition. And ultimately, we succeeded in convincing a court. We have a very lengthy, detailed opinion that explains all of this.
No, I read the opinion. I'm just concerned about the possibility that a company with a superior product paying Apple to someone, this is valuable real estate. You can't just ask Apple to give the real estate to whoever wants it.
Right. Again, the case focuses not on the fact that there were payments, that companies are engaging in commercial contracts. The case focuses on the conditions that accompany those payments. And I think that's a really important aspect of the opinion. And again, these kinds of exclusive arrangements are not new to antitrust law. They've been discussed for generations. And so the concepts that we brought forward here are well within the mainstream of antitrust enforcement.
Okay, I'm watching a piece that the New York Times wrote not that long ago about regulators close in NVIDIA scrambles for a response. And I read this and I say to myself, is it possible, not unlike when Bobby Kennedy was the Attorney General, that there was a Get Hoffa squad there? I wonder, honestly, whether there is a Get Big Tech squad within the Justice Department.
I can assure you that no such thing exists. We follow the facts and the law. We're about rule of law. But I think it's important to kind of dispel this notion. We want companies to compete. We want companies to succeed. We don't bring very many antitrust actions every year. It's a small handful. And we only do so when the facts and the law support it. I spent, about 2 weeks ago, I was out in the Bay Area, and I spent time with VCs, founders from across the technology industry. And what I heard was that they overwhelmingly support our tech cases. Why? Because they want to build and invest in businesses that have the opportunity to succeed and become durable and thrive on the competitive stage. That's exactly what we want to promote, and that's exactly why antitrust enforcement exists in the first place. We're not interested in necessarily regulating companies. We are interested in making sure that the competitive market works so that the market can pick winners and losers, not the government or anyone else or a monopolist for that matter.